Afternoon, ladies and gentlemen, and welcome back. Now, as the final session for today, session 3 will be conducted under the topic of the legal regime of the continental shelf. Her Excellency Ida Caracciolo, Judge of the International Tribunal for the Law of the Sea, will moderate this session. And Judge Caracciolo, please, the stage is yours.
Thank you. Good afternoon, everybody. From the outset, let me to thank deeply the Korean Ministry of Foreign Affairs and the Korean Society of International Law, which co-organized with ICLS this conference. And I also wish to thank them for their warm hospitality here in Seoul. I'm delighted to be back here in Korea, and I am also delighted to moderate this panel. Nearly 70 years after its creation, the continental shelf regime proves to be still controversial, and it continues to fuel questions of interpretation and application that have been the subject of much commented jurisprudence and passionate, I must say, theoretical debates. Indeed, the semi-innovative origin of the continental shelf, its constitutionary nature, its link, even if diverse, to the EZ on the one hand and the area on the other, and the framework structure of Part 6 devoted to the regime of the continental shelf are among the reasons at the basis of these never-ending controversies about the regime of the continental shelf. So I'm sure that the speakers and the discussants will have much to tell us and comment on such a thorny topic, and we will listen to them attentively to have more ideas and more food for thought. Well, without any further ado, I give now the floor to the first speaker, which is Professor Sir Malcolm EVANS. He is principal of Regent's Park College in Oxford. Until 2022, he was professor of public international law at the University of Bristol, where he served also as head of the School of Law and dean of the Faculty of Social Sciences and Law. He is a well-known expert in the law of the sea and human rights law, and he operated actively in the fields of human rights law. He is also an associate member of the Institut du Droit International. Professor Sir Malcolm EVANS, you have the floor.
Well, thank you very much, and it is a great privilege and pleasure to be here today, and let me add my thanks to the organisers of this wonderful event. I normally would at this say something about my thanks to the speakers which have gone before me, but I'm conspicuously not going to, because in many ways they have said much that I was planning to say. But I see this as, first of all, merely reinforcement and not in any sense, should we say, going to prevent me saying what I was planning to say anyway. I'm particularly grateful that many of them have adopted the same approach as I am planning to take, which is to focus on the continental shelf from the three words that make up the focus of our conference here today, the then, the now, and the future. And I will use that as the frame as we move on. As regards the continental shelf, when is then? Well, as has been mentioned several times, although it is only 30 years since the entry into force of the Law of the Sea Convention, it reflects a consensus, and it's worth stressing, it reflects a consensus that was arrived back in 1982, so in some ways the then is about 40 years ago. But as we have been reminded by other speakers, if we project back only that same length of time, 40 years, before the conclusion of the 1982 Convention, we find ourselves in 1942, in an era in which there was no real such thing as a regime of the continental shelf at all. For all practical purposes, the origin of the regime lies in the Truman Proclamation of 1945. When it was made, the Truman Proclamation, in truth, was a very unformed thing. It was a unilateral claim to jurisdiction and control over the natural resources of the seabed and subsoil of the areas of the continental shelf beneath the high seas but contiguous to the coasts of the United States. And with one or two other little bits and bobs, that was about it. Just about nothing of that was particularly clear, other than one thing: the purpose of the exercise, which was, in a nutshell, preserving and prudently utilizing natural resources. This presentation is not going to be a history lesson, other than to make this point. There has been nothing static about the continental shelf regime in the approximately 80 years it has been known to international law. The sketch found in the Truman Proclamation was elaborated on by the International Law Commission, and then, of course, the adoption of the 1958 Geneva Convention on the Continental Shelf only some 13 years later. And the core idea, perhaps unsurprisingly, of facilitating exploration and exploitation, in this instance of hydrocarbons, underpinned them both. The spatial extent of the continental shelf in 1958 was basically a combination of the best guess of the technological possibilities of doing so, coupled with a savings clause lest that proved inadequate. Then it was, by and large, all about exploitation. By the time of UNCLOS III, there was very much more at play than merely exploitation. And as a result, the continental shelf regime set out in the 1982 Convention is very different from that set out in the 1958 Convention. Indeed, it is not, in some senses, a regime of the continental shelf at all. The ICJ has only recently acknowledged it is about giving coastal states exclusive rights to resource jurisdiction to a distance of 200 nautical miles, and further again if geology, geomorphology, and geography permit. In doing this, it is possible to argue that the 1982 Convention was possibly the single largest territorial land grab in modern history, if not in history at all. We may argue at length about the reasons for this, but ensuring a more equitable distribution of resource jurisdiction, both between states and the international community as a whole, in the guise of the area, and the common heritage of mankind, was certainly a dominant theme. But the package deal nature of the convention and the trade-offs that this brought made it difficult and ultimately unrewarding, I think, to go into this much further. The underlying point I wish to make is that access to and control over resources remained the dominant purpose of the exercise, but broader contextual and political factors shaped the manner in which that was done, and resulted in a huge extension of coastal state jurisdiction over those resources and control. The underlying message then is that the new interests produced changed consensus and changed understandings of the continental shelf regime. So that was the then. What of the now? I'm something in a minority, certainly in this gathering and possibly well beyond it, in thinking that although the Law of the Sea Convention is described as a constitution of the oceans, it really isn't one. In a way, I think it would be helpful if it were. If it were a constitution, it would likely be more of a set of more general principles, a little like the freedom of the seas, which could then be more easily reimagined to take account of the changing times. But it is a treaty, a densely written one at that. And so when we want to work out what it is, we are faced with some difficulties and some tools that we have to work towards. If there's anything approaching universal consensus about anything to do with the law of the sea, it is that the Law of the Sea Convention is not going to be renegotiated en bloc anytime soon. And therefore, unless there is some sort of move to develop it, either through protocols, implementing agreements, etc., that we know of, then it is basically what it is, and therefore subject either to development by interpretation and, of course, through judicial and arbitral decisions. Against this background, I want to highlight some of the most significant issues that we currently face regarding the continental shelf. None will come as a surprise, but I will categorize them into two groups. First, I will consider as a part of what we could call the now question, because they are issues which I think can effectively be addressed and ought to be capable of being addressed within the current framework of the law of the sea and with the normal apparatus of the convention. But they are parts of the now which do, in my view, need attention. The first concerns the outer limit. At least for now, and whatever one might think of it, the International Court of Justice has settled the question of the relationship between the inner and outer continental shelf in the Nicaragua-Colombia case, when it determined that a claim based on natural prolongation beyond 200 nautical miles cannot intrude into a 200 nautical mile continental shelf, or EEZ, drawn from the baselines of another state. Personally, I think there is a good deal that's problematic about this decision, but I think the underlying principle is clear enough. It also means that the continental shelf is now a natural prolongation regime only in a spatial sense. In the real world, this means that states which have a continental margin extending beyond their exclusive economic zone are able to carve out for themselves resource jurisdiction in areas which would otherwise form part of the deep seabed and the common heritage of all states, but they are not able to carve out such a thing for themselves when it is within the jurisdiction of a single state. Arguably, the logic of this is open to question, but it is what it is, and at least for now there appears to be certainty. But what are the consequences of this? In practice, it is likely to shift attention to baselines from which the 200 nautical mile claims are made. Whilst in the context of maritime boundary delimitation, it has become more or less commonplace for courts and tribunals to adopt the baselines that they think are most salient for their matter in hand, it may prove very much more difficult to do this in future, because what one will really be doing at the initial phase is determining where the overlap of entitlement of what to be delimited is. So, I think for the purposes of understanding the continental shelf regime moving forward, there is going to have to be, perhaps paradoxically, a much greater focus on the detail of law relating to baselines. This isn't a bad thing, but I think it is one of the things we were going to have to see. Determining that outer limit remains as frustrating a task as ever. We all know that the Commission on the Limits of the Continental Shelf has a ferocious backlog that means that its recommendations can often take very many years to emerge, and recent research has also cast some doubt on the efficacy of that process too. On the whole, the recommendations that are adopted by states up front tend to be those which reflect the submissions made rather than those do not. But this then also has knock-on consequences for the delimitation of maritime boundaries. It also has consequences for understanding another problem, the generative capacity of maritime boundaries. It took a very long time for Article 121, subsection 3 of the Convention concerning the generative effects of rocks which cannot sustain human habitation or a life of their own to be considered customary international law. There is still, in my view, relatively little consensus about what those provisions actually means. Of course, we have the South China Seas arbitration case, but there is still controversy around that and how that may be applied in future cases. I think for me, one of the things that it may still be necessary to go back to consider are questions of that old-fashioned question of size. An island of sufficient size will not be deprived of its capacity to generate the full suite of maritime zones, even if, in the context of delimitation, they do not receive their full entitlement. But when we are talking about small features, then they should only be entitled to generate broader zones of maritime jurisdiction if they have a significance perhaps greater than their size might suggest. And it makes perfect sense to judge this in terms of some of the criteria which we know from the Convention and the arbitration. But whether that test should apply to all islands, irrespective of all other factors, is possibly a question that still needs some reflection on. And indeed, we have seen in other recent incidents of late that importance of small island features may not only be measured in terms of their economic significance or whether they can sustain human life or habitation. As we now all know, the strategic importance of small island features can be very important indeed, and in the real world influences the way that states respond to situations and their actions. Whether this is something that we also need to take into account is another question to reflect on. As time is short, there is more I could say about other matters, particularly the need to think perhaps a little bit more, again, about the difference between low tide elevations and islands. Other speakers at some length, and rightly, have focused on the effects of climate change in relation to these matters, and whether or not there should be such a marked disparity of impact upon about whether something is a low tide elevation or an island in what is so difficult a set of circumstances as around determining whether something is one or the other. And of course, with the changes that are afoot, again, is a question that we might wish to reflect on over time. These may all seem somewhat tangential questions as regards the continental shelf, but I don't think they are. We really do need to know what the basis of entitlement is, and thus to what areas states are entitled. It's as simple as that. And then, of course, we get on to boundary delimitation. I was never not going to mention maritime boundary delimitation, as this remains a topic which generates still a considerable numbers of controversies. Arguably, the principles are now surprisingly straightforward. The difficulty is applying them to the facts of the various cases. What I think I would like to do is just highlight a couple of the problems associated with maritime delimitation, which really are problems which still, in my view, need to be solved. The first concerns determining the extent of overlapping zones. This ought to seem a very straightforward pastime. All the points previously made in relation to determining outer limits of the generative capacity of maritime features, however, indicate that this may not be so. So these are matters which, again, need some reflection. The second is a product of the interplay between the work of the Commission on the Limits of the Seas and the process of boundary delimitation between states itself. You cannot know for certain that a state has an entitlement to an outer continental shelf until the state concerned has established its outer limit on the basis of CLCS recommendations. And we have heard this morning, so I will not repeat, the issues that we now have and the approaches of courts and tribunals to navigate the problems caused by the lack of such recommendations in a timely fashion, or the ability of parties to request that decisions are not made on these submissions because they may trench upon a maritime boundary dispute between them. The idea of significant uncertainty is, as has been highlighted, a useful way forward here, but what this ultimately does is perpetuate uncertainty into an area where clarity over time is needed. And it is not entirely sure how that is going to be practically resolved in the time frames we would wish. And then we have another practical problem, which I think flows from the Nicaragua and Colombia case on the process of maritime boundary delimitation, and this concerns grey areas. I'm fortified by the comments of President Haider this morning, who not only has explained grey zones, and so avoiding me the need to do so, but also for his pointing out that one of the difficulties that we have as a result of the Nicaragua-Colombia case is that it could lead to a situation in which if you shift an equidistance line, we end up with a really rather strange result. It may be that grey zones are incompatible with the statement of principle set out in that case, that a state cannot exercise jurisdiction over an area of continental shelf more than 200 nautical miles from its own baselines, but within 200 nautical miles of another coast, because this is precisely what anything other than an equidistance line, once it is moved, actually produces. And so once again, I think there is something fairly fundamental that we have to think of about how we apply this in the context of maritime delimitation cases moving forward. 'Twas ever thus. Problems arise, problems need to be solved. Perhaps they can all be done within the envelope of the Law of the Sea Convention, but what from this short list that we can see is that the idea after 30 years of jurisprudence we have perhaps a clearer understanding of the detail of the regime is possibly misplaced. If anything, we have at least as many problems than we had before, and perhaps more than we actually thought likely at this point. But what of the future? Well, it follows from what I've said that if there are some issues which I think can be addressed from within the current regime of the continental shelf, then there may be others which possibly cannot, or even if they can, arguably ought not. The Law of the Sea Convention was designed for a purpose, as I indicated earlier. But maybe, just maybe, the underlying purpose and rationale of what we are looking for from the Law of the Sea Convention in relation to the continental shelf is actually changing. Look at the things which other speakers have already said about what the interests here are. There are a number of different competing tensions. First of all, we have the old point about wanting to secure the stability of boundaries. It's always been important to the Law of the Sea, and certainly it has been a factor militating against the opening up of settled boundaries in the light of new information, facts or concerns. Is this going to remain the case into the future when new issues or new concerns come into play, Or is the stability of boundaries so fixed in our minds that it just becomes what it says, fixed? Things do change, though perhaps, fortunately, in relation to some changes, the obligation not to recognise consequences of illegal acts may delay the need to revisit some of these changed circumstances. But others, that is not true of. Look at many of the points which others have already touched upon today. And then the entire history of the continental shelf regime, in fact, has been one of radical instability, not of stability, as regards its outer limits and the extent of maritime claims themselves, the basis of title. All these things have changed quite majorly over the relatively short life of the regime. States which previously had no overlapping claims suddenly find that they do, as a result of changed understandings. New problems arise. And one of those, relating to stability of boundaries, has been the debate over, for example, whether baselines are ambulatory or whether they are not. There is certainly debate about now. Of course, the logic of the convention might suggest that such baselines are ambulatory. The low or low water line is obviously ambulatory. Let's face it, it does so twice every day. So why do we say that it isn't? At what point, however, is it to be fixed? And we have our rules in order to do that. And they are logical, and they make sense. But if one's claim becomes so divorced from the basis of title and of reality, do they continue to make sense into the future? There are indeed arguments either way on the question of ambulatory baselines, but the point about the debate today is it really about baselines in the law of the sea, whether they should or whether they should not ambulate, or whether it is about something else altogether? Whether it is about climate change, whether it and the effects on small island states, for example. And if so, is the answer to those questions rightly to be distilled from thinking only of the law of the sea? If, as some speakers have pointed out, we may have a situation in which entire states disappear under the waves, the idea that this has no consequence or impact, for example, on the idea of statehood, recognition of statehood, continuity of statehood, and a whole host of other things is difficult to imagine. Not all problems which manifest at sea are necessarily problems of the law of the sea, and looking only to the law of the sea as a means to solve them is not necessarily the best way to proceed in all instances. As time is nearly up, I will just very briefly highlight a few other of the main challenges which have already been flagged as things that we need to address. Security. Boundaries are all about limits and who can do what where, and the security of one's territory is paramount. Our first speaker today showed that the capacity of states to exercise security over activities taking place within its continental shelf is in fact surprisingly limited. And we have heard only in the last session about some of the broader security concerns that are now resulting as strategic attention shifts more towards the continental shelf from a strategic rather than a purely economic point of view. The use of the continental shelf for military purposes has ambiguity enough, but now add to that what we know about the provisions concerning cables, pipelines, etc., which have been already amply and eloquently described today in terms of the fundamentals of infrastructure. And as regards, without wishing to make any assumptions about what underlies the severance of the cables only today between Finland and Germany, it is also just the case that very major military exercises are now taking place in Finland as a NATO country. If there is a problem in relation to the severance of those, can we be sure it is simply a law of the sea problem, or is it bound up in other things as well? But the need to be able to protect increasingly vital infrastructure on the continental shelf is apparent and growing. we do need to think about that. Is the way to do, what factors do we need to take into account as we settle that? Are they only to be those pertinent to the law of the sea, or more besides? And in a nutshell, as I come to conclude, what we can see is the overall changing nature of the interests that states have in the continental shelf. This fundamental change, it has broadened from being largely concerned with the exploration and exploitation of hydrocarbons towards interests, first as regards other resources, other economic uses, and now to entirely different uses: underwater carbon capture, cool storage. There are also changed strategic priorities, and of course heightened interests in decarbonisation, preservation of the marine ecosystem, and so on. All things which 80 years ago would have probably confused and bemused many of those who fashioned the regime as we know it today. So, where does this leave us? Finally, to return to the more overarching approach of my opening observation, we may now need to ask again what the continental shelf regime is actually for, or more precisely, whether it currently is for, what it is currently for, and effectively reflects what the international community wants it to deliver into the future. The regime only exists because it was created to achieve a regulatory purpose. It was never an end in itself. And if we now need it or want it to be different, then perhaps we ought to think about it holistically. Given that all states now have a 200-mile continental shelf and an entitlement to a 200-mile exclusive economic zone, it may be, as an earlier speaker hinted, we may not need the continental shelf regime at all. I think we all know why we have it. When this was put into place in the convention, there were still powerful arguments from those broad shelf states that wished to have more. Would we still accept that today if those negotiations were taking place? I don't know. Whether that is still a desirable, as desirable a purpose as it once was, is, I think, increasingly debatable. If we think, therefore, about what we see, there is a real danger that we end up, arguably as I have just done, spending too much time and energy addressing what we could call the now questions, because they can be addressed, rather than thinking of new ways of addressing the future questions. Back in 1945, the continental shelf was a now answer, a new answer to a future problem. Today, we are wrestling with the problems now posed by those, frankly, then solutions. What we need to do is to seek what we could call now solutions to the future problems. But basically, this is all proving rather difficult. And it could be that the continental shelf regime, as currently understood, simply may not be able to provide them in the way that we wish. But if that is the case, then we will just have to accept that and do the best we can with what we have. Thank you.
Thank you, Professor Sir Malcolm Evans. In an ideal world, maybe the law would have been carved in stone, but unfortunately or fortunately, we live in a real world, so there is a continuous tension between human behaviors and laws, trying one to overcome the other and vice versa. Thank you for this overview, critical and evolutive on the regime of the continental shelf.